Warm welcome to the SAIS community and SAIS friends. My name is Nina Gardner, an adjunct professor at SAIS, where I've been teaching corporate sustainability, business, and human rights for the last 10 years, and a practitioner working with companies and investors on human rights and environmental and social governance issues. I'm extremely honored to moderate my colleagues from the International Law program, who are also practitioners on the domestic law front and policy, and who have taught as adjuncts at SAIS for a total of 52 years. I will be the moderator for the next 90 minutes. The presentation should take about an hour, and we will leave 30 minutes for Q&A at the end. So if you have a burning question, please enter it in the Q&A box with your name and affiliation, and I will read and direct them to the appropriate person. As soon as the Dobbs decision was leaked, it became clear that we were in need of another Schneebaum Scotus Tour de Force Roundup. This is the third year he has been doing it. Previously, it was for the International Law Society, and we are extremely happy to be doing this now for the SAIS community at large. The stakes have never been higher for all of us. So we'll start with an introduction of Professor Schneebaum. For those of you who have not had the pleasure of taking one of his classes, Professor Schneebaum is a SAIS institution and has been teaching at SAIS for 32 years. His current courses are the International Human Rights Clinic, Law Clinic, and a wonderful course, the U.S. Constitution and in the International System, which he will be teaching next fall. In years past, he has also taught international law. In real life, he's a litigator and a practitioner of international law. He has decades of experience on U.S. death row habeas cases in Virginia, Texas, and currently in Alabama, and argued for the state and at the state and appellate level and filed numerous briefs up to and including the Supreme Court. So as you can tell, we have the perfect person to explain what has been called a momentous and extremely activist 2021-22 session of the U.S. Supreme Court. He has promised to cover the major cases in 40 minutes. Not easy, but I'm confident he can do it. We will then turn to Professor Dan McGraw, who has been teaching international environmental law at SAIS for almost 20 years, this fall teaching international law and the environment, crisis and cooperation, an apt title, I may add. He has worked on environmental matters at the EPA, 9 years as director of the EPA's International Law Office, and he has worked at the White House and on the USTR's Trade and Environmental Policy Advisory Committee under 4 presidents, 2 Republican and 2 Democrats. He has been working on constitutional law issues since 1978 and climate change since the early 1980s. He will be commenting 10 minutes on the impacts of the West Virginia versus EPA case. So I would say, without further ado, I turn the floor to Professor Schneebaum for his Scotus Roundup. Stephen?
Well, thank you very much, Nina. My colleague and friend, Nina Gardner, is always too kind in her introductions. But I'm grateful to her not only for her words, but for her work in organizing this event. And it is a testament to the strength of the International Law program at SAIS that I can share this virtual platform today with Nina, who is a world-renowned expert in the field of business and human rights, and with Dan McGraw, a pioneer in international environmental law. When I presented a recap of the 2019 term of the US Supreme Court 2 years ago, I began with these words. This has been indeed a historic year for the court, by far the most consequential Supreme Court term so far this century. I had good reason to say so then, yet that term of the court pales in significance compared with what has just come down from the justices. Today, we will review 4 areas in which Supreme Court decisions have been no less than explosive: separation of church and state, the right to bear arms, abortion, and the powers of administrative agencies to set rules, especially regarding threats to our environment, on which Professor McGraw will offer his expert views. These were among over 60 opinions issued by the court after briefing and argument this year, along with other important cases decided in what is aptly called the shadow docket. I have to begin with an obvious, unavoidable observation. In every one of the cases we will discuss, the 6 justices appointed by Republican presidents were in the majority, and the 3 put on the court by Democrats were the dissenters. This in itself marks a historic shift from the traditions of the court. Chief Justice John Marshall wrote in the landmark case of Marbury v. Madison that the role of the court is, quote, to say what the law is. But it gets a little hard for Americans to believe that what is handed down from the court is free of politics when the divisions have become so stark and so partisan. When Justice Antonin Scalia, in a dissent, told his colleague Justice Anthony Kennedy a few years ago to hide his head in a bag, he was roundly criticized as intemperate. But that, unfortunately, has become the norm, not the exception. Some of this mistrust derives from justices' increasing willingness to engage openly in politics when they are off the bench. Justice Thomas, for example, has complained that in their confirmation hearings, Republican nominees for the High Court, but not Democratic ones, have been, in his word, trashed. Remarkably, this was months after Justice Ketanji Brown Jackson was accused by Republican senators of being an enabler of pedophiles. Justice Brett Kavanaugh, in his hearings, portrayed himself as the victim of what he called, quote, a political hit fueled with apparent pent-up anger about the 2016 election and revenge on behalf of the Clintons and millions of dollars in money from outside left-wing opposition groups. This outburst was so striking that it provoked retired Justice John Paul Stevens to opine that Kavanaugh was not fit to sit on the court. Justice Thomas's participation in partisan political life is especially troubling, compounded by his wife's rather remarkable involvement in denying the outcome of the 2020 presidential election. It does not help that the justice has not seen fit to recuse himself in cases concerning that very issue. And of course, the means by which the current branch was constituted is relevant too. The refusal of a hearing to President Obama's nominee, Merrick Garland, the current Attorney General, while not unconstitutional, was unprecedented and struck many Americans as inconsistent with good faith and fair play. Some Republicans, including unusually Justice Thomas himself, have tried to justify the treatment of the Garland nomination under what they claim was a Democrat-sponsored rule that a judicial appointment hearing should never be held during a presidential election year. But there was never such a rule, and Republicans, of course, stampeded the confirmation of Justice Barrett through the Senate just days before the election of 2020. And it is a fact that 3 of the 6 justices in the majority in the cases we will discuss were appointed by a president who lost the popular vote and were confirmed by senators representing far less than half of the country. All of this, even before the decisions announced 2 weeks ago, has sharply eroded Americans' respect for the court as a fair and neutral institution. When 5 justices installed George W. Bush as President of the United States in 2000, Justice Stevens prophesied this very outcome. He wrote that the court's decision, delving so deeply into foreign politics, in his words, can only lend credence to the most cynical appraisal of the work of judges throughout the land. It is confidence in the men and women who administer the judicial system that is the true backbone of the rule of law. Time will one day heal the wound to that confidence that will be inflicted by today's decision. One thing, however, is certain. Although we may never know with complete certainty the identity of the winner of this year's presidential election, back in 2000, the identity of the loser is perfectly clear. It is the nation's confidence in the judge as an impartial guardian of the rule of law. At the same time, it is extremely troubling to hear voices from the left protesting that the unelected justices of the Supreme Court have too much power over our lives and that their authority should be constrained by the popular will. That position is deeply frightening. The genius of the Constitution lies precisely in the fact that the founders placed certain rights and the obligations of the government to protect those rights beyond the mercurial will of the people. The First Amendment proclaims that Congress shall make no law abridging or restricting certain freedoms. And under the 14th Amendment, the states may not do so either, even if the people support such a law virtually unanimously. It is far from clear that in 1954, there was consensus among the American people that the segregation of schools based on race was unacceptable. But constitutional rights are not to be affected by popular opinion. That is why the drafters of the Constitution were so careful in the language of the Bill of Rights. And it is why they included the 9th Amendment, which reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." So, what are the rights that the people have, and how do we identify them? That is the ground on which the divisions among the justices of the current court must be understood. The question is not whether there are unlisted rights, it is how to locate them and how to restrain the government from infringing them. The conservative members of the court claim that originalism is the key to constitutional interpretation. That means that the language of the Constitution should be read as it was understood by the founders in the 1780s. A variant of that approach is called textualism, by which only its words and not any extrinsic source dictate the meaning of the Constitution. Yet the founders were conscious that norms and customs would change as the country changed. They deliberately bequeathed to us open textured language, leaving precise meanings to later legislatures, courts, and citizens to sort out. The first 8 amendments to the Constitution protect rights that were of special concern to former colonists who had just thrown off the English crown. There would be no state religion, for example, and no bar to the espousal of different religions. The judiciary would be constrained by standards, and criticism of the government would be robust and free. But the drafters did not attempt to lock in future generations. For example, they prohibited cruel and unusual punishment, but they did not specify what that meant. They wrote that excessive bail and excessive fines could not be imposed by judges, but they did not indicate what might count as excessive. The theme that will run through our presentations of the individual cases is that the majority did not adhere to their espoused theories of how the Constitution should be interpreted. They rushed to judgment when they did not need to, despite the Chief Justice's admonition that if it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. In Dobbs, the court was not asked to overrule Roe v. Wade, it did so anyway. In West Virginia, the rule that the court was addressing was not in effect, and the opinion goes far beyond the four corners of the dispute before the court. In the religion cases, and the case relating to concealed weapons, the court likewise showed a willingness to ignore precedent and to make new rules way outside its proper function. All of these demonstrate precisely the kind of judicial activism, the lack of judicial restraint, of which the conservative side of the political spectrum has always accused the liberals. And I am confident that next term we'll see even more of this kind of activism, because that is what the political faction that put these men and women on the court favor. Now let's turn to the cases. First, Kennedy against Bremerton School District and Carson v. Macon. The Constitution provides that neither the federal government nor the states may establish a church or prohibit the free exercise of religion. Although these provisions at times overlap and even conflict, decades-old precedents in this area still provoke controversy in some circles, but their application has been reasonably consistent. The government may not endorse a religion, may not be seen as preferring religion over non-religion, may not use public funds for the promulgation of sectarian doctrine. Thus, public schools may not require or even encourage students to participate in religious activities, nor may they teach such things as creationism or intelligent design. Furthermore, while public funds may be made available to schools that have religious affiliations, they may not be used to promote religious curriculums. The basic principle here is what Thomas Jefferson called the separation of church and state. Over 50 years ago, in assessing programs making taxpayers' money available to private institutions, the court offered what is usually called the Lemon Test. A proposed expenditure will not violate the Constitution if it has a secular purpose, its primary effect neither advances nor inhibits religion, and it does not foster excessive entanglement between the government and religious institutions. This is hardly a perfect solution to address a question that frequently arises, but it is, and has been shown to be, a workable one. The Roberts Court has for some time eroded the Lemon Test. In Town of Greece against Galloway in 2014, the court saw no problem in a New York Township Council beginning its public meetings with a Christian prayer. But in the Kennedy decision just issued, the court announced the demise of Lemon altogether, without saying what should replace it. Kennedy concerned a high school football coach in the state of Washington who knelt to pray on the 50-yard line after games. His employment contract was not renewed after he was ordered to stop, and he sued. He lost in the lower courts, but the Supreme Court reversed in a 6-3 vote, holding that Kennedy's dismissal violated his rights to both free exercise of religion and free speech. Now, it seems obvious that a prayer by a school official in a context where it is clear that he or she is acting in a purely private capacity is permissible. A teacher may say grace or may make the sign of the cross before lunch in the school cafeteria. The question in Kennedy was whether the coach's prayer was private, or whether it suggested to a reasonable observer the endorsement of the public school that employed him. Justice Gorsuch held that Kennedy was acting as a private individual, not a school employee, when in the middle of the football field where his team had just finished a game, in front of stands still full of people, he performed a Christian ritual. The Carson case arose from a very unusual set of facts. The population of the state of Maine is so dispersed that many small counties cannot provide a public high school. The state legislature, enacted a law offering parents tuition money to send their children to private schools, so long as the schools are accredited and are non-sectarian. Maine defined that term, non-sectarian, on the basis of the content of the educational curriculum. An eligible school could not, as the law was written, promote the faith or belief system with which it is associated and or present the academic material taught through the lens of the faith, unquote. Two families wished to send their daughters to fundamentalist Christian schools in Maine and applied for funding, but they were turned down. Chief Justice Roberts, writing for the 6-3 majority, held that Maine not only may, but must offer tuition subsidies to students attending those schools, and that the failure to do so renders the Maine program unconstitutional. Justices Breyer, Sotomayor, and Kagan dissented. Now, the court has for decades permitted the use of public funds to support religiously connected institutions that offer secular services. Think of universities like Georgetown, or Yeshiva, or Texas Christian. It has never allowed the use of taxpayers' money to teach religion. Yet, one of the schools at issue in Carson states on its website that its goal is, quote, to help every student develop a truly Christian worldview by integrating studies with the truths of Scripture. Carson permits the use of public funds to support this very clearly sectarian institution in the promotion of those religious values. Justice Alito, in a concurrence 2 years ago, suggested that the views of religious people must be accommodated despite the mandatory secular nature of public education itself. He wrote, many parents of many different faiths still believe that their local schools inculcate a worldview that is antithetical to what they teach at home. Now, while obviously such parents have the perfect right to seek education for their children elsewhere, the court has now permitted them to demand public funds to pay for that choice. In declaring the end of the Lemon Test in Kennedy, and in requiring Maine taxpayers to pay for students to receive a Christian education in Carson, the court has overturned the precedents insisting that the First Amendment protects not only the right of people to exercise their religion, but the rights of others not to have religion imposed on them. In the majority's America, persons of other faiths or of none at all may be forced to underwrite the costs of teaching, for example, quote, the truths of Scripture. In that America, government officials may promote religion in their official capacities, as Kennedy did. These results are grounded in neither history nor precedent. They are anchored in preference. The justices in the majority believe that this is a nation in which religion is not purely a private matter, but should be supported by government actors and government money. I turn now to New York State Rifle and Pistol Association against Bruin. The Second Amendment says, I'm reading, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This is the only provision of the Constitution in which the founders revealed the purpose of protected rights. The First Amendment, for example, does not say the role of the media being necessary to keeping the government transparent and accountable, Congress shall make no law abridging freedom of the press. It doesn't say that. But whether the right to bear arms is restricted by that preface has been foreclosed by the court since 2008. The court held in Heller against the District of Columbia that the right to bear arms is an individual one. Justice Scalia wrote for the 5-4 majority in Heller that the Second Amendment is violated by any prohibition against keeping, and I quote, a lawful firearm in the home operable for the purpose of immediate self-defense, unquote. 2 years later, in McDonald v. Chicago, the court held that the Second Amendment also applies to the states. But let's look again at Justice Scalia's conclusion. The District of Columbia in Heller had to allow people to own weapons, A, in their own home, and B, for the purpose of self-defense. The more attentive listeners among you will have noticed that the Second Amendment includes no limitation as to either location or objective beyond the one, of course, that the Heller court expressly disavowed. So the court must have been relying on something else, not the language of the amendment, something outside the text of the amendment, which is to say, something inadmissible under the theory of textualism. And although Justice Thomas's concurrence and Justice David Souter's dissent provided contrasting versions of history, both of them looked at history, not text and not original intent, to determine the scope of the right to keep and bear arms. This sleight of hand by the court, of course, is completely understandable. It would be impossible to read the Second Amendment as suggesting that any arms may be kept and borne by any person at any time in any place. That would be absurd. The Heller Court specifically said that state licensing rules are not precluded, which means that states may regulate who may carry a firearm, even banning guns completely from what the Heller Court called sensitive places. So the court in Heller did not, in fact, and could not, underwrite a restriction-free interpretation of the Second Amendment. That judges recognize limitations on constitutional rights is hardly unusual. The First Amendment, for example, says that Congress may pass no law abridging the freedom of speech. But that does not suggest that incitement to riot or perjury or fraud cannot be prohibited. The court has held that the right to free expression of religion does not mean that states, for example, may allow or must allow the use of drugs in religious services. Bruin concerned a century-old New York state statute that required a showing of good cause before someone could be licensed to carry a concealed weapon in public. 6 justices of the court found the law unconstitutional. But when Justice Thomas wrote that, quote, "We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need," he was engaging in pure sophistry. Constitutional rights may be and regularly are made subject to regulation and even to the requirement of official permission. To obtain the tax exemption that is the constitutional right of churches, you must satisfy the Internal Revenue Service that your institution qualifies under government-issued rules. And Heller acknowledges that Second Amendment rights themselves may be made dependent on satisfying state-created criteria. Even Justice Thomas would presumably prefer that concealed weapons not be carried into his workplace on First Street Northeast here in Washington. Bruin does not mean that states may not restrict who may own and carry guns, what kinds of weapons they may have, and where those arms may be introduced. What it does mean is far less clear. Bruin will surely lead to a flood of litigation to define the sensitive places into which, by applicable state law, you may not bring your pistol. New York argued that all of Manhattan qualifies as a sensitive place. The court rejected that contention, but it did so based not on logic, text, or empirical evidence, but on an appeal to history. Justice Thomas dismissed the argument because, in his words, there is no historical basis for New York to effectively declare the island of Manhattan a sensitive place. Is there really not? Is the danger of large-scale mayhem in America's most densely populated city not something the court can take into account? No guidance was offered by Justice Thomas about what might actually count as historical basis for evaluating sensitivity. Apparently what he said, what might be said of historical basis is that unlike Justice Potter Stewart in the famous pornography case, Justice Thomas knows it when he doesn't see it. If Manhattan is not a sensitive place, what about New York City subways or the Washington Metro? Why is a government building bristling with armed police a sensitive place, while the University of Michigan football stadium, capable of holding 115,000 human beings, is not? Are elementary schools, say in Uvalde, Texas, or Sandy Hook, Connecticut, sensitive places? Will their status change if teachers are suddenly packing heat, or if armed guards are patrolling their halls? Presumably, after Bruin, the owners, custodians, or managers of particular venues will have to justify their status as sensitive in court if necessary, and only then might any restriction on the carrying of concealed lethal weapons be upheld. 2 consequences of Bruin are absolutely certain. First, people will die, because virtually anyone may now carry a concealed weapon in public without hindrance. And second, the courts will be flooded with cases challenging state restrictions. Judges will have to search for historical evidence that a 4th of July parade or wherever the next mass shooting will occur is or is not a sensitive place. In Bruin and in the religion cases, all of the justices agreed that the states may not tamper with constitutional rights. Yet in determining the coverage of that term, the rights in the Constitution, which are inviolable, as opposed to those created by the government, which are not, the majority has shown no dedication to precedent and no consistency with their own theories of constitutional interpretation. They have handed down opinions driven not by case law, not by logic, and not by any coherent theory of how a judge should, to quote John Marshall again, say what the law is, but rather by their political preference. Now, with that in mind, I turn to the highest profile of this term's cases, Dobbs against Jackson Women's Health Organization. To understand Dobbs, it is necessary to understand the precedents that it overruled. The 1973 decision in Roe v. Wade and the 1992 case of Planned Parenthood of Southeastern Pennsylvania v. Casey. Of course, the Supreme Court is not bound by stare decisis, a rule of judicial creation and certainly not a constitutional requirement. And its sudden elevation into liberal dogma strikes me as at least somewhat ironic. We liberals certainly had no objection when the court annulled Plessy v. Ferguson in 1954. We cheered when the court in 2003 overruled Bowers v. Hardwick, which had permitted states to criminalize same-sex intimacy between consenting adults. Justice Alito is absolutely correct when he says that the doctrine does not prohibit the court from overruling an earlier decision that is, in his words, egregiously wrong from the start. The question, however, is not about the logic of that conclusion, but about its premise. Was Roe so obviously wrong? Roe was decided in substantial part in reliance on a case called Griswold v. Connecticut, a 1965 decision that struck down a Connecticut statute barring access to information about birth control. And although the opinion for the court by Justice William Douglas regrettably included mystical musings about emanations and penumbras, the bases for that outcome were twofold. First, the right to privacy, the right of individuals to make decisions about the most intimate aspects of their lives, including marriage and procreation, is an unenumerated right that comes within the Ninth Amendment's purview. And second, as such, it is one of the liberties protected from government interference without due process of law. Justice Harry Blackmun in Roe went far beyond what he needed to do to find the Texas statute at issue unconstitutional. He laid out an elaborate structure by which the constitutional right to abortion was nearly absolute in the first trimester of a pregnancy, subject to restrictions but not outright ban in the second, and capable of outright denial in the third. Critically, though, the majority found that before the time of fetal viability, which was around 6 months at the time Roe was decided, it was a woman's right to choose to terminate her pregnancy. And that right, supported by 6 votes to 3, 4 in the majority appointed by Republican presidents, was grounded in the Due Process Clause of the 14th Amendment. Casey dismantled Blackmun's trimester analysis, but it left in place, in an opinion jointly written by 3 Republican appointees, including the court's first female justice, upholding the basic principles of Roe. Pre-viability, states may not impose an undue burden on a woman's right to decide to end a pregnancy. Numerous cases in the Supreme Court have applied Casey over 3 decades. Yet, of course, the controversy about abortion never abated. And because the links between that controversy and partisan politics have been so profound, it has been clear for years that once reliably anti-abortion justices became the majority, Roe and Casey would be overruled. The death of Justice Ruth Ginsburg provided that opportunity. There was little doubt about the outcome in Dobbs even before the draft opinion was shockingly leaked. The former president of the United States regularly promised that he would appoint justices who would strike down Roe, and for once, he kept his word. The Supreme Court has long observed that while stare decisis is not a requirement it must follow, precedents are not to be overruled unless doing so is strictly necessary. But that tradition too fell victim to the determination of Justice Alito and his colleagues to do what the politicians with whom they aligned wanted done. They could not permit a legislative ban on abortion at the state level unless they could deny the existence of a constitutional right. The upshot of all of the sound and fury about Dobbs is precisely this. As the Chief Justice plaintively observed in his concurrence, the outcome of Dobbs could have been reconciled with Roe and Casey. The court could simply have concluded that the Mississippi statute at issue, banning abortions after 15 weeks, did not present an undue burden. This could have been based on the empirical fact that medical progress has accelerated the moment of fetal viability. But the majority opinion found no historical evidence of a specific constitutional right to abortion. What the justices should have sought, and what they would easily have found, is plenty of evidence of the constitutional right to privacy, to bodily integrity, to individual agency. As the Griswold Court observed, many of the provisions of the Bill of Rights are illustrations of that right. Private spaces may not be searched without a warrant. Homes may not be appropriated for the quartering of soldiers. Private property may not be seized without due process of law. All of these underscore a right, a constitutional right, an unalienable right, as the Ninth Amendment provides, retained by the people, the right to be left alone. Whether and to what extent the right to end a pregnancy is part of that right is not entirely obvious. Surely there are state interests that might be understood as limiting it, including the proximity of a fetus to the ability to survive on its own. That is what Justice Blackmun's trimester structure in Roe attempted to emphasize, and the same balancing of interests underlies the decision in Casey. But Dobbs simply explodes all of that, not by virtue of persuasive legal analysis, but because of the court's eagerness to carry out a political agenda. Of course, the Dobbs decision does not make abortion illegal. It allows the states to do that. Dobbs has been portrayed by some as a victory for democracy because it allows elected officials to decide a question very obviously of enormous public importance and controversy. But this argument is wrong for two reasons. First, denying that a right qualifies for constitutional protection means that it is conferred by the government and may be altered, restricted, or revoked by the government. It may be granted by some states, conditioned in others, denied in others still. The existence of constitutional rights, however, which are not subject to popular whims, is the cornerstone of democratic governance, not an exception to it. We do not have votes to decide whether a Muslim community may build and attend a mosque in our neighborhoods. The second flaw in the argument is the assumption that devolution of the decision regarding whether abortion should be legal to state legislatures promotes democratic participation. Given the degree of partisan gerrymandering and the increased barriers to voting that we are now witnessing in many states, there is little reason to believe that those bodies accurately reflect the will of the people. Of course, if we accept that a fetus is a human being from the moment of conception, then Roe and Casey are indefensible. And the outcome of Dobbs, even if not its reasoning, is clearly correct. Yet, in Roe itself, the court specifically addressed the question of fetal personhood and decided according to good originalist and textualist principles that when the drafters of the Constitution used the word person, they did not intend the unborn. Furthermore, to the extent that fetal personhood claims are grounded in religion and not science, as they most frequently are, assessing them is entirely outside the province of the courts and of the government as a whole. Much attention has deservedly been paid to Justice Thomas's concurrence in Dobbs. It is Justice Thomas's view that a right must be expressly named or acknowledged in the Constitution, or it simply does not exist. Using that framework, he suggested that Griswold and cases relying on it, including cases concerning gay rights, such as Obergefell v. Hodges on gay marriage, and Lawrence v. Texas on criminalization of gay sexual activity, should be reconsidered. And the protestations of the majority in Dobbs, as well as in the concurrence by Justice Kavanaugh, that the decision is limited to abortion and nothing else, are plainly disingenuous. If the Dobbs outcome can be defended because abortion is not a right recognized in the Constitution or contemporaneous records, it is hard to see how, as a matter of logic, Justice Thomas's wrecking ball approach to the constitutional rights can be resisted. I think it is unlikely, but far from impossible, that the current court will go as far as its most radical members would have it go. The draconian limitation of constitutionally guaranteed rights is inconsistent with too much of the ethos of America, and our deference to history is less than Justice Thomas's. This is not only because in the years that he considers to be decisive, all of the laws were made, interpreted, and enforced by men, and by white men at that. It is not only because there have been such dramatic changes in all aspects of this country's life. It is because our Constitution was meant, and until now has been held, to be a living document reflecting the values not only of the time at which it was written, but of our times and of future times. The founders of our nation never contemplated that the meaning of the text they bequeathed to us was forever to be locked in the narrow perimeter of their world. Yet this is the legacy of the 2021-22 term of the United States Supreme Court. And I suspect that the task of rights defenders following these decisions will be only the prevention of future erosion. I wish I could conclude on a happier note. I'm now going to hand the virtual microphone to my friend, Professor McGraw, to tell you about West Virginia v. Environmental Protection Agency, another case of far-reaching importance, which also did not require the slashing and burning of precedent to which this court seems committed. Following him, Professor Gardner will offer some thoughts on potential consequences of the Dobbs decision, and then we will all be pleased to entertain your questions and comments. Thank you very much for your attention.
Thank you, Stephen. Can you hear me?
We can.
Good. Can you see me?
Yes.
Excellent. Well, let me start. Thank you again, Stephen, for that stirring rendition of what's happened. As Stephen said, I'm going to talk about a different case. It's no less important and no less startling in its reasoning and outcome. West Virginia versus the Environmental Protection Agency, EPA. The posture and holdings of the case are kind of complicated, so let me start with those. In 2016, the EPA promulgated a rule under Section 111 of the Clean Air Act. You don't have to remember that number particularly, but it dealt with climate change. And the idea was to try to move the generation of power away from dirty sources, particularly coal, to clean sources, particularly different kinds of green energy, solar, wind, etc. This was immediately challenged in court, and the Supreme Court immediately stayed the application of the rule. Now, it was challenged in lower courts, and they had not yet had a chance to consider it. and this is an important point when Stephen talked about slash and burn. This is the first time in history that I know of that the Supreme Court has stayed a rule promulgated that way before the lower courts had had a chance to consider them. So it's startling in that sense. But in any event, things kept going. In 2019, under a new administration, the EPA promulgated a new rule. That was immediately challenged in court. And the DC Circuit Court of Appeals, which is one layer below the Supreme Court, held that was invalid. The EPA also tried to vacate the earlier one, or repeal it, but it did so in a way that the DC Circuit also said was invalid. Then, of course, we had the election, and the new administration, President Biden's EPA, said that it would not go ahead with either rule and that it would reconsider things. The Supreme Court, nevertheless, decided the case on a rule that didn't exist and the EPA said wasn't going to be reissued. And it did so in the face of the fact that in the real world, not the courts, the changes that the original rule had sought to achieve had already occurred. That is, that on their own, power generating companies had moved away from coal towards these other sources. So nevertheless, we have a decision. Now, the lineup of the court was similar to what we've already heard about. Justice Alito wrote the opinion. He was joined by Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Coney Barrett. There was a concurrence by Gorsuch in which Alito joined. So it's obvious that there was jockeying going on in terms of what the real reasoning was. And then a dissent by Justice Kagan, joined by Justices Breyer and Sotomayor. Now, the majority opinion said, first of all, this is justiciable, even though there isn't a case, even though there isn't a rule anymore that they could rule on, because they said, well, this idea of generation shifting is so important and it hurt so many states who were the plaintiffs that that they could go ahead with it. And that's probably okay. Seen in light of everything else, it's questionable, but in any event, on the merits, they adopted a new test, a new doctrine that they called the major questions doctrine. Now, court watchers had known this was likely to happen given changes in the court's composition, but this is really the first time that it was promulgated or said and applied in such a brazen manner. Now, the basic idea here is that on certain questions, you need to have very clear statutory authority. Now, for an administrative agency like the EPA to act, it always needs administrative authority. That's the basis of our, or statutory authority from Congress. That's the basis on which they operate, and it comes out of the important doctrine of separation of powers, which is embedded in our Constitution. And no one questions that basic doctrine. The question is, what kind of authority is needed, and when do you need this special level? And as I said, this is the first time the court had really announced this doctrine in a majority opinion. And the sources it relies on are really interesting. I don't have time to go into them in detail, but one of them is the EPA itself. It said, well, the EPA decided that the major questions doctrine applied. This is the EPA under President Trump. Now, there hadn't been a major questions doctrine before that, right? This is the first case that really announced it. And the idea that the Supreme Court is looking to the EPA for judicial authority is really extraordinary if you've ever worked in the US government, but even if you haven't, this is not where the Supreme Court normally looks for precedent. In any event, that was the first thing it did. It said there's a major question doctrine. This one applies. Or this one fits within it. It said, oh, but this is limited to extraordinary cases. It looked at things like the history and breadth of the authority that the agency had asserted in the past. And it looked to the quote unquote political and, economic and political, unquote, significance of the assertion, the regulation in question. First of all, it says nothing about social importance, which if they're going to have this kind of doctrine, you think they would take that into account. And second, as I said, the reality was that the power companies had already moved on. So there really wasn't any political and economic, any economic significance anymore. Politically, of course, when one knows that one of the parties doesn't like regulations and doesn't like climate change. So in that sense, there's some political significance. The court went on to say, well, the problem here is that this assertion by the agency goes beyond what Congress could reasonably understood to have granted. Now, I'll come back to that, but that's part of the second line of reasoning. The third is the court did look at the statute, which of course it had to. It said that system, well, the language here, by the way, is the, let me find the exact, best system of emissions reduction, which is the kind of decision that regulatory agencies are competent in making. And it said that the Congress couldn't have meant to do that, and that even though system includes the kind of regulation, that is the definition of the word system, includes the kind of regulation that was at issue here, that's not enough. That Congress couldn't have meant to include these kinds of things. The dissent by, the concurrence by Justice Gorsuch, and again joined by Justice Alito, tried to support this a little more by saying, well, we have other situations where we require a clear statement. Those, I would say, are quite different. For example, in terms of the possible retroactivity of a statute, especially any kind of statute, we need a clear statement of that by Congress. But that's a very easy test to apply. Is it retroactive or is it not? The same has to do with sovereign immunity, which is another example that he gives. So in my view, anyway, this doesn't provide much when you have a major question doctrine, which is so obviously subjective. Very unlike this. And they also referred to something called the Non-Delegation Doctrine, which the majority would not use. The dissent, it begins by quoting from an earlier Supreme Court case, Massachusetts versus EPA, which described climate change as probably the most important environmental issue facing humanity. I would add it's also the most important economic issue and the most important human rights issue, et cetera. But in any event, it starts that way, then it goes through a very careful statutory analysis and finds that, in fact, this is perfectly in line with what Congress intended. And it goes back to something that Stephen already mentioned, this idea of whether the Constitution really set forth a set of principles in a living document that should be applied as society changes, or if it's really a shopping list. And we can see it's not a shopping list, by the way, comparing it to the Declaration of Independence. That is a shopping list. It lists all these things that the king has done wrong. And that's not what the Constitution reads like. But in any event, it's a very different view of what the Constitution and also the 14th Amendment, of course, is like.
Dan, Yeah, we need to
Am
wrap
I
up.
running out of time here?
Yes, you've run out of time.
Okay, well, let me just say, in closing, let me say a couple of things. First, this case is like Dobbs because it is, I think, a vast overreach. I think it takes the wrong view of what the Constitution is like, has serious implications for other areas. And this is very important to say. This test would also apply to issues, Department of Labor, the Securities and Exchange Commission, any kind of health, environment, and public welfare regulations are now open to whatever the court thinks is a major question. And then finally, I say it disregards reality the same way that Dobbs does, and I hope I can come back and comment on that. And it's also like these other cases in that this court was like a bunch of kids in a candy shop. It really wanted to get to these issues, and it did. Thank you.
Okay, thank you very much, Dan. And I ask everyone if they're start writing questions in the Q&A box while I say a few comments about sort of the business implications of both of these decisions, both the EPA one and the Dobbs one, because we'd like a robust discussion in a few minutes. But the EPA decision is as disastrous as a Dobbs decision, although people haven't really processed it yet. And it clearly sends a message and a signal to the business community that they do not have to follow regulatory authority from numerous agencies, starting with the EPA, as Dan said, but including USDA, FDA, Department of Labor. And this signifies that there will be a massive pushback in the courts on nearly every regulation trying to protect citizens' health, safety, public welfare, et cetera. And indeed, we're already seeing pushback from the much-awaited SEC climate reporting regulation that came out this March in the comment letter sent by West Virginia and the Arizona Attorney General and Attorney Generals of 24 other states to the SEC, complaining that the SEC does not, quote, possess legal authority to adopt the proposed rule. We're talking about just climate reporting regulations for investors who want to know what companies are doing in terms of mitigation and adaptation processes. But and then they said that, quote, it violates the First Amendment as the SEC rule request constitutes, quote, unconstitutionally compelled speech, and that the rule is arbitrary and capricious. So we can already expect this case in perhaps the next few terms, and we know what this court will decide. So this is like very, very dangerous. And in terms of just looking at the capital markets, this is going to really put the U.S. back, and I'm very concerned about that. As for the Dobbs decision, this is immediately thrusting all U.S.-based corporations and investors into the uncomfortable position of taking a stance on abortion issues, as many companies from red states are having to decide whether to provide travel and accommodation coverage to their health care packages. They also need to let their employees know whether they will be covering fines. Some of the fines will be starting at $10,000. Because some of these states, like the Texas case, will be fining the enablers. Apart from the values issue, and we could spend hours talking about that, there's a whole financial risk case to be made to these companies, as they will start having serious recruitment and retention issues for their top talent, both for women and men. Because again, if you're going to relocate to Texas, many of these restrictive states, is a decision that impacts entire families. Needless to say, the Supreme Court, we saw the Justice Thomas's, not dissent, but his comment on what this means in terms of privacy rights in general. We're going toward gay rights issues. And of course, you've all been watching, I hope, what's happening with Disney in Florida in terms of the say on gay issues, don't say gay bills. So I've spent the last week working with my clients who are investors, who are trying to be environmental, social, and governance investors, to review their portfolios to map out what states their major holdings are in, and preparing engagement questions for those companies, ranging from what they intend to do on abortion and travel coverage to what kind of lobbying activity they intend to take at the state level, which is now where the battle has shifted. Investors with tech stocks are also engaging on all the privacy issues involved with people's personal data, including, by the way, period tracking apps and search engine information regarding abortion clinics or medicated abortion pills. It just goes on and is a disaster. We're seeing a host of companies stepping up to support their workers in a post-Roe world, as they see it's key to their resiliency. Many businesses are already expanding healthcare access and travel benefits. Some, like Alphabet and Salesforce, are offering relocation services for their employees that want to move out of restricted states. Patagonia, always one of the more progressive companies, has gone so far as to announce that they will offer bail for full and part-time workers who peacefully protest for reproductive rights. And incidentally, they're also one of the few companies that provide paid parental leave and subsidized childcare. And for those of you who are interested in tracking what companies are doing what, Just Capital, which is an NGO following Business Response, the whole host of these issues, is tracking these company responses. From a business and human rights and ESG perspective, this is where companies can really take corporate leadership. And I do hope consumers and potential employees will make their choices accordingly and stay the course, as there will be backlash in the red states. Which brings me to another point. Other major groups impacted are universities and the military. The Dobbs decision is forcing students to add another criterion to their college selection process, whether their college is based in a restrictive or soon-to-be restrictive state. I'm already hearing about students changing to their second choice schools based on this decision. I certainly hope that universities, which are a business as well, will join companies headquartered in the restrictive states to engage with their state representatives to explain to those representatives that these restrictions will have a massive impact on their businesses, and consequently tax money that the state will be able to collect from these entities in the future. Now, on the military, and I don't want to dwell on this, but they are the major, in many of these restrictive states, they are the major employer in these states. But because all the training bases for the military happen to be in these restrictive abortion states. And they are governed, the military is governed by the Hyde Amendment that precludes federal money from being used for abortions. So any woman in the military who is raped or gets pregnant in these states will not have the procedure covered. And so there's some discussion about amending the Hyde Amendment. I hope we can do that. It's not clear. But given this Dobbs verdict, I expect a shortfall in military recruitment for women from blue states who will think twice about relocating, which will hurt the U.S.'s military preparedness. Finally, Dobbs is opening old Civil War fissures, and I fear, unless Congress acts, which is unlikely to do, it seems, we are due for a very bumpy ride ahead. It's my hope that my students will play a role in the companies and NGOs that they are working in to ensure that U.S. companies take an active role in protecting human rights of their employees and their community, be it voting rights, abortion rights, gay rights, or any kind of privacy rights in the years ahead. So I can't be very uplifting, because this is really a disastrous verdict on all counts. But now the irony is that it's the businesses that need to step up and support and protect the human rights of their employees and their community, which is an ironic shift, because you'd expect your government to be doing that, but it's not doing it for the moment. I will end here and open up for questions. So do we have any questions? And does anybody or please raise your hand if you have any questions. Let's see. There are 2 questions. We have a question from Xinjiang Zhao. How to prevent the trend of judicial activism, especially as reflected in the Roe v. Wade case, in the Dobbs case, the personal preferences of the Supreme Court justices playing an important role in judicial decisions. I suspect that's one that we will send to Professor Schneebaum.
Yeah, thanks. Well, let me question the premise of that question. I'm not sure that we want to restrict justices of the Supreme Court from acting like what they are, which is to say, human beings who are entitled to have their views on various matters before the court or before the public. Indeed, some may remember that when Justice Sotomayor was being confirmed by the Senate, someone dug up a speech that she gave some years before in which she said something about how the courts would benefit from the voice of a wise Latina. And she was roundly savage for that, because everyone said, she's indicating that she's going to decide cases certain ways because of what her ethnic background is. And of course, that's not what she was saying at all. What she was saying was that she brings her experiences to the court, as we want all of our judges at all levels to do. We don't want our judges to be computers or to be robots. That said, the issue really isn't restraining the justices from expressing their personal views or coloring their decisions with personal attitudes. The issue arises when the judge's personal views conflict with their judicial obligations. And that's what we're seeing here. So, is there any way of forcing Supreme Court justices, individually or collectively, to do a better job of reading the Constitution? In a word, no, not in our system. I guess it's theoretically possible that the court could be expanded to dilute the influence of the current members, but I think that's highly unlikely, and I'm not sure what kind of precedent that would set anyway. But I don't think it could happen politically. So I think we simply have to ride this one out. And I think one thing that lawyers can do and that law professors can do is to ensure that the questions that the court is asked are questions that cannot be easily dodged and cannot be easily fudged. And in other words, I think if the justices are going to say we don't care about precedent anymore, I think we ought to make them say that. And I don't think they will.
Okay, I'd love to see more questions. In the meantime, I am going to ask another question because you were constrained on time and didn't really tiptoe into what we can expect from the next term, and then I'll ask Daniel. But what are the biggest cases to watch? I think there's going to be one, again, revisiting affirmative action in universities and employment, and some on conservative state legislatures and what their rights will be going forward. And I think there's a gay rights case out of Colorado, I believe. So can you comment on those? And I don't think any of them are going to make us very happy either.
Sure. Well, yeah, probably not. There is a glimmer of hope in the gay rights space, because in a decision that that I think is one of the great outliers of recent Supreme Court jurisprudence, a case called Bostock v. Clayton County in 2 years ago, 2021. In an opinion by Justice Gorsuch, the court held that the Civil Rights Act of 1964, which prohibits discrimination based on sex, should also be read as prohibiting discrimination in employment based on sexual orientation. Now, to reach that conclusion, he had to be a strict textualist, and he was. He said, in effect, look, I know that in 1964, when this bill was enacted by the US Congress, there isn't a single member of either house who would have thought that what they were doing was eliminating the possibility of discrimination based on sexual orientation. It was the furthest thing from their minds. Nobody focused on, nobody thought about it. But the words that they wrote govern, said Justice Gorsuch. The words that they wrote govern, and those words can only be interpreted, and he goes through the logic, I think persuasively, to suggest that that means that discrimination based on sex includes discrimination based on sexual orientation. So there may be some glimmer of hope there. I also think that given that Obergefell, the gay marriage case, seems to have been accepted by the American people, to the surprise of many, as just something fair and right and acceptable and normal and not a problem, that poking that hornet's nest, I think, would really provoke something that the court doesn't want to provoke. So I'm hopeful on the gay rights side. With respect to the affirmative action, no, not hopeful there at all. That is the case involving, among other places, Harvard.
Yeah.
As a Yaley, I can't help but gloat a little bit about that. But still, that case, I think, is doomed. But the real big one is the voting rights case. And the voting rights case comes down to a very simple proposition. The Constitution says that the rules for carrying out federal elections shall be as determined by the legislatures of the separate states. Now, what does that mean? The legislatures of the separate states may set rules, and they all have, all 50 of them have, but are those rules constrained by anything? Well, obviously they're constrained by the US Constitution. So they can't deny equal protection. They can't prevent Black people or women or people who are over 18 from voting. They can't do that. The Constitution forbids that. But there are other constraints on state legislation that are imposed by state constitutions. And state Supreme Courts, obviously, are the ultimate interpreters of state constitutions. So the question before the court is, do state courts have any role to play in evaluating, in passing on the constitutionality of state regulation of federal elections? Now, it seems to me that what is at stake there, frankly, is nothing less than Marbury v. Madison, because in Marbury v. Madison, the Supreme Court famously said, it doesn't matter what the legislature does. We have a higher calling. This court has a higher calling. Our oath is to the Constitution, not to some bill that might have been passed by Congress. And we will overturn bills that or laws that we find to be inconsistent with the federal Constitution. I can't think of any reason why state courts or state constitutions should be thought of differently from that. However, state legislatures are easily manipulated. They're very political. We all know that. We have states in which both houses of the legislature are securely held by Republicans, while the state voted for Joe Biden in 2020, or has a majority of Democrats in its congressional delegation, yet the state legislature is Republican. We also know that in many states, for reasons lost in the mists of time, judges are still elected. Dreadful, dreadful system. Sandra Day O'Connor gave the last years of her life to trying to defeat that notion. But in any case, in many states they are. And those judges, those justices who are elected by the people with party affiliations, guess what? They intend to carry out their party's mandates once they're in office, whether they're wearing black robes or not. So I think that there is a lot to be fearful of in the decision on voting rights, because if state legislatures are not regulated by state Supreme Courts and they're not regulated by federal Supreme Courts, then they can do almost anything without judicial review. And we believe fundamentally, going back to 1803, in the notion of judicial review. It's really critical to the entire architecture of our Constitution. Long answer to a short question, sorry.
Oh, I'm going to ask, I see Dan, Professor McGraw wants to ask a question, and then Malik, I will read a question that Malika Dia sent in the Q&A. Keep on sending questions. Dan.
Thank you. Can you hear me?
Yes.
Good. Well, first, with respect to the first question, I think there may be systemic changes that could be made. For example, limiting the terms of Supreme Court justices. So I guess I disagree with Stephen a bit on that. in terms of Justice Thomas, there are rules about impeaching federal judges. They go through Congress. I think the likelihood of that happening is very, very, very low. I think he should have recused himself from at least one of the cases in which he ruled, but I don't think that you're going to get any Republicans to agree to either impeach or to convict him after that. So, and I think the political fallout would be very strong. So, from a political point of view, I kind of hope it doesn't happen. I do want to say one thing about Dobbs that really bothers me, and Stephen didn't mention it. First, the whole notion, he did mention one thing, and that is that this notion that the Constitution and the 14th Amendment don't change from when these white guys voted. Of course, I can't accept that. It ignores the whole process of changing and recognizing the proper role of women in our society, for example, and their freedoms. But in addition, it's clear that they were thinking about pregnancy and forced pregnancy. At the time, we have whitewashed slavery, but it is absolutely clear that overseers and owners were raping slave women, and that they were forcing slaves to have sex in order to breed more slaves. And they were forcing women then to keep those pregnancies. These were, I hate to talk this way, but this is what was happening. And people knew that at the time. And so in fact, they were thinking about forced pregnancies and making women carry babies. So to say that they weren't, which is what the Supreme Court now says, the majority said, well, they weren't thinking about this. That's false. It's historically false. And we see this kind of selective choosing of history and facts in many of these cases. In Bruin, you see it as well. It really is a horrible thing. It should be recognized. It has to be said about this majority that they're ignoring that. And that obviously undercuts the credibility of the opinion, although the ruling still stands. Thank you.
Okay, we have lots of questions pouring in, and Malika, one of our star students, asked about the possibility of impeachment of Clarence Thomas, but I think that's sort of been covered. So I'm going to move to another question, unless anyone has anything they particularly want to say about that. But I think there's the question here of from Alexandra Utria. Do you think this will set a precedent if, I think she's talking about a number of these cases, it'll set a precedent of majority judges overturning past cases, i.e. stare decisis out the window, meaning if we get a Democratic majority Supreme Court again, could the overturning of Roe v. Wade get overturned? Good question.
Sure. Yes. Answer is yes. Of course it could. But there's nothing new in that.
Right.
Right. I mean, again, we have seen regularly, at least in recent times, the court overturning a precedent. Sometimes, again, as a liberal observer of such things, sometimes I like the outcome, sometimes I don't. But the Supreme Court is not bound by precedent. That is true, has been true, and shall always be true. Now, are these decisions particularly vulnerable? Probably. But bear one important thing in mind. The court decides cases that are presented to it that actually are cases and controversies between actors. So in order for another case to come before the Supreme Court that tests Dobbs, there would have to be a case or controversy. There might have to be a state whose abortion restrictions are challenged, or someone argues that some constitutional right has been restricted by a state law. And I imagine that right now, as we speak, creative lawyers and organizations that have a stake in the outcome are thinking about this very hard. How can we how can we tee up cases that will climb the ladder to the Supreme Court and that will actually give us a shot at overturning Dobbs or overturning Bruen or overturning the religion cases. It's going to be hard. It's going to be hard because the courts of appeals, the district courts, the courts of appeals are bound by this decision. The Supreme Court itself is not. It takes years for cases to climb up the ladder to the Supreme Court. And maybe by that time, we'll have a different makeup of the court. Maybe.
Okay, we have many questions from Michael Shipnizer. So do you think that Congress could validly pass a law giving all women in the U.S. a right to an abortion? If so, what constitutional power would such a law rely on? And do you think that the law would survive challenge post-Dobbs?
Yeah, I don't. First of all, laws don't generally give rights. That's not how laws are normally phrased. At the moment, after all, there is no reason why anybody can't have any sort of medical procedure done on them if they're willing and their doctor is willing, unless to the extent, or as restrained or restricted or forbidden by state laws. The mere idea that the Congress of the United States could say, yeah, we think abortion's fine, we don't think there should be any restrictions, even up to 10 minutes before what would have been a normal birth. That's fine, just go ahead. That certainly would not prevent states from banning abortion or restricting it. And again, the Supreme Court would need to sort that out. So I don't think there's any grounds for it. Again, the federal government is a government of limited jurisdiction. If it doesn't have jurisdiction granted in the Constitution, it doesn't have it. I don't see where that would be in the Constitution.
Okay, we have a question about, we have a lot of questions about the Dobbs decision, but I'm going to move to the Bruen case. So New York State has enacted now, this is from Thomas Gatto, what many would consider a more restrictive set of regulations surrounding concealed carry than had previously been in effect. Do you foresee a situation where the court strikes down a state law, then continues to revisit the state's response over and over again? For example, as you said, Stephen, the court stated the island of Manhattan could not be considered a sensitive area. Instead, the state declared the entire Adirondack Park a sensitive area, hundreds of times larger than Manhattan. At what point is the court writing legislation?
I think that horse is out of the barn, I think. But the court will have to write legislation, and it will have to deal. This is going to be, those of you who are old enough to remember this is going to be as bad as the court's involvement in drawing school districts back in the days when busing was the hot topic, and the courts had to come up with incredibly granular formulae for determining how many students needed to be in a particular public school in order to provide the proper racial balance. Here, it's going to be very, very tough for the court to articulate what makes a sensitive space. Manhattan is not, but that's not just because Manhattan is big. At least that's not what Justice Thomas said. He didn't say it's too big a place. We can't have a place that covers that many square meters. So the idea that a national park or a state park could be deemed a sensitive place presumably would be assessed, weighed, found wanting or not wanting, based on whether a park can be called a sensitive place. Maybe, I doubt it, frankly, because Justice Thomas is always going to come back to the historical basis. Where is the historical basis that says you shouldn't be allowed to bring a firearm into a park? In fact, many parks have hunting as a feature. People go hunting there. Of course you can bring firearms. So where is the logical, historical, empirical, any other grounding for a determination that Adirondack Park can't be deemed a sensitive place yet? Okay, what about Central Park? What about the subway system? I mean, the creativity of legislators will be taxed to the maximum over the next little bit, and the courts will have to sort it out each and every time, even if they were to say transportation systems, generally speaking, are not sensitive places. Well, excuse me, what about the Washington Metro that goes underneath the Capitol building and underneath the Supreme Court? Does that make it a sensitive? And so on and so on and so on.
So we are at time, but we started a few minutes late, so we're gonna take one more question from an incoming SAIS student. We always love those, from Luke Stewart, who asked, Professor Schneebaum asserted that putting rights up to a vote is a dangerous idea. While he doesn't disagree, Ireland legalized same-sex marriage through a referendum, and Ireland in many ways appears to be a more functional and representative democracy than the US at the moment. Could you speak a bit more about why voting on rights is a dangerous path and what practical action should be taken by Americans dissatisfied with recent court decisions? I think it's a good one to end on.
Sure. Sure. Well, I mean, the snarky answer to that question would be because that's not what the founders gave us. They gave us a constitution that enshrines rights, not one that makes rights subject to voting. But the reason that they did that, of course, was that they were painfully aware that, for example, minority religions were not always tolerated in England. Minority religions are not, always tolerated in the United States today in 2022. If anybody who is aware of Islamophobia or anti-Semitism that occurs in this country, or the hatred of people who appear to be Asian, even when they're not, and so on, that kind of impassioned social separation is precisely, I think, what made the founders decide that they did not want fundamental rights to be up for a vote. Are we all confident that the First Amendment would pass a popular vote today? I'm not, because I've heard people argue too many times that First Amendment rights should be restricted and that people shouldn't be allowed to divulge secrets or various kinds of things, shouldn't be allowed to urge anti-government action and so on. The founders gave us a system in which those things are forever embedded in our legal norms. That's not to say there's anything wrong with what happened in Ireland or in other countries in which gay marriage has been approved by referendum, but they do not have the same constitutional history or structure that we do. So maybe in their systems, the only way to bring about what I, and I guess many others, think is basic fairness to people whose romantic interests are of the same sex, is to amend the Constitution or to have some sort of a referendum or a plebiscite. So be it. But that's not our constitutional system.
Oh, thank you. Well, I have to quote Tim Fang here, who says, with all these arguably negative decisions, how shall we stay positive and still have faith in the courts or even America? I won't ask you all to comment on it, but that was a very appropriate comment. And I will close with just these last thoughts. Is just, we've had the most concentrated decision since 1931 by number and sweeping nature. And it's erased basically, thanks to the way Professor Schneebaum and McGraw have recounted half a century of court precedent. This has been called a YOLO court. I don't know if you've heard that expression. You only live once. So this court and these justices are grabbing what they can, which is not good for what people used to believe was the most apolitical branch of government. The Gallup poll now says that only 25% of the American citizens trust the Supreme Court, and I suspect it will go down even further. And it is just very depressing to see what's happening. We'll see what the next term brings, but we are confident that we will have Professor Schneebaum to give us a roundup of the 22-23 Supreme Court terms next year at around this time. But I thank you all for hanging in there, asking lots of great questions. We had a lot of questions we couldn't answer, but thank you all for your participation. And with this, I will close.